We have major breaking news as the United States Department of Justice for Pam Bondi and Donald Trump have submitted a brief in the United States District Court down there in Texas dealing with this challenge to the National Firearms Act arising from the One Big Beautiful Bill. And I have to say, although I've been supportive of this Department of Justice, the reality is I am disappointed with this brief. I think it has made many errors. I think it is not up to snuff. And I'm not sure what happened here, but we're going to break down the mistakes made, in my view, in this brief and why it's simply inconsistent with not just the Second Amendment, but with Article 1 of the Constitution and general law of Supreme Court precedents. We're going to break it all down in a geeky way when we come right back. Hey folks, I'm Mark Smith, host of the 4Box of Nine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, before we break down this brief by the Trump Department of Justice, I want to let you all know, thank you again. I've just found out I've been renominated to be the top voice of the Second Amendment yet again for 2026. So we'll be talking more about that in the future. But again, I'm always honored and privileged to receive even a nomination. Whether I win or not, that's a separate question, but I'm always honored to be thanked and supported by our Second Amendment community. All right, folks, now we got to get down to it. So I've been a few days late on this story because I had a ton of other work I had to get done, including an article I published in the Harvard Journal of Law and Public Policy, and I had a Second Amendment conference I had to go to, among other things. So I'm now getting to this big hubbub on the internet, in social media, over whether or not the Attorney General Pam Bondi and the lawyers in the Department of Justice somehow screwed up and betrayed the Second Amendment in this case of Silencer Shop Foundation versus Pam Bondi ATF. And the answer is yes, they did totally mess this brief up, mess these arguments up, not just on the Second Amendment, but also under the Commerce Clause and the taxing authority of Article 1. And yes, I am disappointed in this brief. I really have to ask myself who was monitoring this brief, if anyone. I do understand that this is a district court, a trial court, and those briefs sometimes don't get the attention they need from the higher ups. I don't know whether or not that's the case here or not, but one way or the other, we're going to break down why I think this Department of Justice brief defending the National Firearms Act is simply wrong in all respects, in my opinion. So with that said, let's just start with one observation I want to make about social media over the last few days. There was a perplexing tweet put out by somebody I support, Harmy Dillon, and apparently someone at the Department of Justice about this brief. Specifically, after this brief was submitted in this case, which of course deals with whether or not the enactment of the One Big Beautiful Bill and the removal of the $200 tax stamp from the sale of suppressors, short barrel rifles, short barrel shotguns, and the like, whether or not that gives rise to the fact that the NFA, as applied to those items and those transfers to consumers from FFLs, whether or not that makes the NFL, as applied to those things, unconstitutional for various reasons. And in my view, the answer is yes, it makes it unconstitutional. We'll get to that in 1 second. But with that said, there was a lot of pushback on this brief that basically said, what's wrong with this brief? Why is Pam Bondi, the Attorney General, and Donald Trump taking this position that seems counter to the Second Amendment and very favorable to the gun controllers? And I think that is an absolutely fair question to be asking. And frankly, having analyzed this brief extensively, I do think there's a lot of mistakes made, which we're going to get to in a moment. With that said, there was pushback by apparently some people at the Department of Justice and Harmy Dillon that essentially said that if you don't like this law, don't challenge it in court, go back to Congress. Now, that's nonsense in my view, because the reality is we already went to Congress as the Second Amendment community, and the National Firearms Act was already changed. So now we're just trying to enforce the logical extension of that legislative change, which makes this law unconstitutional as applied to the $200 tax stamp and the registration requirements for suppressor short barrel rifles and short barrel shotguns. But just to give you some context, here is the back and forth X account posting between Harmy Dillon and somebody at the Department of Justice back and forth on social media over the weekend. Check out this now. Here you have somebody named Gates McGavick, who I don't know, saying, hey guys, as you've previously pointed out, Congress is the issue here, not DOJ. Registration requirements may be a bad idea, but it's a worse idea to have courts overturn the rule of Congress unilaterally. You guys know that AG Bondi is a staunch 2A advocate, but that doesn't, and then it kind of goes on from there. And then that was reposted by Harmy Dillon, who I very much like, and I think has been very good for the Second Amendment overall, but she reposts, don't like bad gun laws, ? Tell Congress. Okay, I don't know what they're thinking. This is clearly wrong. Clearly wrong. There is simply judicial review. There has been since Marbury versus Madison and Chief Justice John Marshall. This is not a new thing at all. And yes, we do want the courts to overturn unconstitutional acts of Congress. And you should not say that you should go out and change the law when the law was literally just changed with the one big beautiful bill. And now the consequence of that change, meaning the removal of that $200 tax stamp, is that the NFA, as applied to these specific so-called NFA items, is unconstitutional. And it may be unconstitutional anyway for a reason we're going to get to in one moment. So I don't think it's an answer to say, go talk to Congress. I think we already talked to Congress. Congress already acted, and now it's up to the courts to enforce the law as it is currently written and understood. Okay, so now let's get down to brass tacks. The first thing is this brief by the Department of Justice conflates two things and basically gets things backwards. The first question is really, are these items, suppressor short barrel rifles and short barrel shotguns, are they protected arms under the Second Amendment? Because if they are, it means that the NFA on its face is unconstitutional, regardless of our congressional power. To begin with, as you know, the way you analyze whether or not an arm is protected is you look at the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. We know from the Supreme Court precedent under Heller and others that an arm is anything that can be used offensively or defensively, and that includes, quote, any instrument that helps or facilitates armed self-defense. Now, with those definitions, we know that, well, as a matter of plain text, that suppressors are clearly arms. In fact, the Department of Justice, this very Department of Justice in the Peterson case, literally said that suppressors are arms as a matter of the plain text. We also know that short barrel shotguns and short barrel rifles are arms because they are firearms, and there's no more quintessential arm in American life than firearms. So at a plain, and you can carry all these things in your hand so you don't get into the tank battleship question. So these are clearly bearable arms. So as a matter of plain text, short barrel shotguns, short barrel rifles, and suppressors under the NFA are clearly arms for the purposes of the plain text of the Second Amendment. And if you're going to regulate them and or try to ban them and or register them and or tax them, obviously that is a regulation. You are regulating arms-bearing conduct because you're regulating arms, which means what? You know what it means. The burden shifts to the government under the Second Amendment analysis of Bruin and Heller, and it's up to the government. That's right. In this case, the Trump Department of Justice, it's up to them to satisfy their burden that they can regulate, ban, or register or tax these particular items, short barrel shotguns, short barrel rifles, and suppressors. Which means the burden is on the government, in this case the Trump DOJ, the Bondi DOJ, to demonstrate that these are dangerous and unusual weapons. And as we've talked about in that very detailed 40-minute video I did a few weeks ago, the way to understand that conjunctive phrase of dangerous and unusual has nothing to do with the criminal misuse of arms. A criminal misuse of arms has nothing to do with making something dangerous and unusual. Something that is unusual is obviously by definition not common. So the first thing the government would have to show is these particular weapons are not common. They certainly cannot do that with suppressors. There's over 4 million suppressors in the United States that we know of registered, so those are clearly in common use. And I think when it comes to short barrel rifles, you have close to 1 million or somewhere around 1 million that are in common use as well. And of course, when you come to deal with short barrel rifles, as a practical matter, it makes no sense logically to have handguns, which are really short barrel rifles if you think about it, because handguns have rifling in their bore. So you really have handguns are really the ultimate short barrel rifle, by the way. And then, of course, presumably, we know the AR-15s and semi-automatic rifles are protected under the Second Amendment. Why? Because literally this Department of Justice in the Barnett case in the Seventh Circuit, as well as the Cheeseman case in the Third Circuit, have literally said in briefs that they agree that bans on AR-15s and semi-automatic rifles are unconstitutional because they are protected under the Second Amendment. So you have long guns with rifling are protected. You have short guns, i.e. handguns, that are protected under the Second Amendment. So how do you possibly reach a conclusion that guns that are in between in terms of size, like a short barrel rifle, is not also protected under the Second Amendment? It strains credulity. So with all that said, what does this brief by the Department of Justice do? It does none of things of the thing I just said. It literally doesn't talk about how these are unusually dangerous. Specifically, you can't use criminal misuse to make something unusually dangerous. It has to be unusually dangerous by virtue of what it does to the user or to collateral damage, such as, again, mines, NFA items, perfectly fine, grenades, explosive devices, machine guns, which I know is a little bit of a stretch to us purists out here, but when it comes to Supreme Court precedent, I think machine guns would fall into this because it's hard to control for ordinary civilians as a practical matter. And I think even arguably short barrel shotguns maybe, just maybe, could be viewed as a dangerous and unusual weapons. I think that's a little bit of a line call. But with that said, when you're dealing with short barrel rifles and you're dealing with suppressors, I don't see how that can possibly be dangerous and unusual. And again, if the government cannot show that these particular arms are dangerous and unusual in their briefing before this particular particular court, they cannot win the case. And why is that? Because if they cannot demonstrate their burden, if the DOJ cannot show their burden is that these are dangerous and unusual arms, which they're not able to do because they put in no evidence that I could see or no arguments about this. And as a consequence, they're protected arms under the Second Amendment. And if an arm is a protected arm under the Second Amendment, then means, number one, it cannot be banned, but these are not technically arms ban cases. The NFA is different. It's a targeted tax case, and it is a registration case. Now, obviously, if it is a protected arm, we know it cannot be taxed because under the Harper versus Board of Elections case from Virginia, Supreme Court case, as well as the Minneapolis Star case, you cannot have a targeted tax on a protected constitutional activity, and the possession of a arm that is protected under the Second Amendment, if you target a tax like an NFA item or an NFA tax, that is unconstitutional. But here it's not really an issue because it's become a moot point because Congress has eliminated the $200 tax. So you don't have to worry about that. But again, that $200 tax is probably unconstitutional even if it continued to exist. And that is something I think the Trump Department of Justice should have known. The second thing, of course, is registration requirements are clearly unconstitutional. Here in this brief, the Department of Justice is trying to draw a comparison using that terrible Peterson case, which is a suppressor case out of the U.S. Court of Appeals for the Fifth Circuit. You know, that's the case that we covered extensively that was so screwed up that you had a panel decision by Judge Jennifer Elrod, a lovely lady, but unfortunately she screwed this one up big time when Judge Jennifer Elrod issued that decision that says that suppressors are not protected arms even under the plain text. That was completely wrong. And of course, it was so badly reasoned that she actually withdrew their three-judge panel opinion and then reissued another one that says, yeah, we agree suppressors are under the plain text arms, but they have these other nonsensical reasons why they can still be regulated, which is clearly wrong. And there's a request for that case to be heard en banc by the Fifth Circuit. I think there's a good chance the Fifth Circuit will hear that case and overturn that terrible Peterson precedent. But the point is the Department of Justice here is literally relying on that absurd Peterson opinion, even knowing, I suspect they should know, that that is a three-judge panel decision that is probably on very thin jurisprudential ice, and why you would try to hang your legal hat on that is, I'm not sure I would do that, but again, I don't work for the Department of Justice. So again, now that we found out, now that it's pretty clear to me that suppressor, short barrel rifle, short barrel shotguns are protected arms under the Second Amendment because the DOJ has done nothing here to satisfy its burden that they're not, except cites to some, old case law, which I don't think is going to get them over the hump of showing these are dangerous, unusual weapons, which is what they have to prove. And because they can't do that, these arms are protected. And as a consequence, the only thing they can show or try to argue is that the registration requirement is constitutional, but that's clearly not the case. The best evidence of this is that literally since America started, since General Gage took the arms from the Bostonians. And remember, the British soldiers leave Boston to arrest Samuel Adams and John Hancock and to seize the arms the Patriots had been accumulating. And that gave rise to the shot heard round the road. And subsequent to that, the British general basically ordered everyone in Boston to turn in their arms. And ever since then, we've been worried about confiscation of arms, which is a reason why we have the Second Amendment. And one of the great things, or one of the best things for an anti-gun or gun controller is to have a registration list of all the gun owners and guns in America, because you know where to go to round them up. And Justice Brett Kavanaugh, when he was a judge on the U.S. Court of Appeals for the D.C. Circuit in 2011, literally wrote in dissent in the Heller 2 case that there is no historical tradition in America of gun registration. And yet here you have in this NFA right now being enforced by the Trump administration, wrongly in my opinion, is a registration requirement. It is simply absurd that they're ignoring the views of the dissent by Justice then Judge Brett Kavanaugh, pointing out there is literally no historical tradition of firearms or gun owner registration. In fact, not only is there no history there, and Justice Brett Kavanaugh has already indicated that, indeed, even as late as World War II, they're literally talking about how we can't have gun registrations and stuff like that in America, because that's not how we do things. And here you have the Trump administration and Pam Bondi trying to uphold a gun registration regime under the NFA, and if these items are protected arms under the Second Amendment, which they clearly are because they haven't demonstrated that they're not, and the burden is on the government, it means they cannot be registered, they cannot be taxed, they cannot be banned. So this brief basically gets this all backwards because they needed to analyze the Second Amendment question of whether or not these are protected arms under the Second Amendment first and foremost, because if they are, then it doesn't even matter whether or not Congress has the power to enact the NFA, whether or not Congress has the power to enact the Gun Control Act. It doesn't even matter at that point because it's a practical matter. The regulation that's being deployed here, which is the registration and fingerprinting of gun owners and connecting them to protected arms under the Second Amendment, cannot fly because there's no historical tradition of such laws and regulations regulations in the United States, so it's a bye-bye. Now, with that said, to make it even more absurd, this brief literally is citing to case law and to laws that come way too late in time. And this is just a pet peeve of mine because it's clear the correct answer is if you're trying to understand the meaning of the Second Amendment when it was adopted in the year of our Lord, 1791, one would think the best evidence in terms of history is the time period around 1791 when everyone is still alive. Instead, if you look at footnote number 9 here in this DOJ brief, they're literally talking about cases from the late 19th century, even going so far to cite, believe it or not, a case in the 20th century, which everyone understands to be entirely absurd. In fact, here's what they write in their footnote. Similarly, many states have long regulated the size of firearms. See id, collecting examples of states banning or taxing pocket pistols, and then the footnote reads, citing the State versus Kerner, a North Carolina 1921 case, also an Andrews versus Tate, which is an 1871 case, an Arkansas case from 1876, and an Arkansas case from 1878. Obviously, all too late in time. That tells us literally nothing about the 1791 Second Amendment, something that occurred over 100 years later after the Civil War. It's simply absurd reasoning in my view. But let's go beyond that, and let's now address the two other issues here, specifically the Commerce Clause argument and the tax argument. Let's start off with the tax argument. Now, this is, to me, simply bollocks. Now, I've got to get a little geeky here. Just to understand, and I'm sure you guys know this better than I do, many of the people in the gun industry, so I'm going to keep it general. There are two kinds of taxes you need to generally understand here in this case. There's what are known as special occupancy taxes, SOT taxes. So if you're in the business of selling firearms, if you're in the business of making firearms, you need a special occupation tax, which by definition, what is an occupation? It's a job. If you're in the business working as a company, you need to pay this tax. This tax, listen carefully, is paid once a year. It's an annual tax. This is a different tax. This is important, folks. This is a different tax than the tax that was removed by the Donald Trump One Big Beautiful Bill, which was the $200 tax that applies to the transfer from an FFL to an ordinary American, such as myself, such as you, such as Bob down the street. That $200 transfer tax is a separate tax from the special occupation tax, or the SOT tax. The reason why this is important is that the $200 tax on the transfer to the private consumer from the FFL has been eliminated by the One Big Beautiful Bill, but the special occupation tax, the SOT tax, was not eliminated. So what does the Department of Justice do here? I cannot believe they're making this absurd argument. It is insane. They're literally arguing that to make sure that gun dealers, listen carefully, to make sure that gun dealers and gun makers pay the special occupation tax every year, that one-time annual payment, like a bar membership payment you pay every year as a lawyer, or, an AMA thing you pay as a doctor, whatever it is, an annual payment just to keep your bar license up, your medical license up to speed, whatever it is. That's all this is. They're literally arguing that to make sure, listen carefully, you're not going to believe this, to make sure that gun dealers and people engaged in the business of buying and selling and transferring guns for a living, to make sure that those people comply with the National Firearms Act and the law, it is important and essential that people like Mark Smith and you personally, when you buy an NFA item, a suppressor, short barrel rifle, short barrel shotgun from an FFL, that you have to turn in your fingerprints and register that item. How are these things possibly connected? Their argument is that the only way to make sure that the people engaged in the business of firearms have paid the special occupation tax is to make sure that the people acquiring suppressors, short barrel rifles, and short barrel shotguns as consumers register those items as send in their fingerprints to make sure that no one is running afoul of the SOT tax. Now let's think about this hypothetically. I know this is high abstract reasoning. Not everyone can get this, but at my level, you can get it. And the people who watch this channel, you can get it too. Although not everyone can. Let's just think abstractly about a hypothetical. Let's just assume that Congress enacts a special occupation tax for people in the business of selling groceries. Supermarkets have to get a special occupation tax that allows them to sell groceries. Okay? Let's assume Congress could do that. They probably could legally under the Commerce Clause. Let's say they do that. Okay, they do that. Okay? All right. Now, according to the DOJ's logic in this brief, what does that mean? That means that they, under the taxing power of Article 1 of the U.S. Constitution, would have the authority to force every single American that buys groceries to turn over your fingerprints and register all of your groceries and disclose all your groceries to the federal government under the taxing authority, because according to the theory advanced by the Department of Justice in this brief, to make sure the taxing authority is complied with, you can force the consumers of those products to get their fingerprints taken by the government and to register those items. And again, if you hypothetically had a special grocer's tax paid annually to the federal government to sell groceries, that would be the same as saying that we need to make sure that the people that are selling groceries are paying that tax. And to ensure that's the case, we want every American that buys groceries, every time they buy groceries, to, even if they don't pay any taxes, we want them to register those groceries and to submit fingerprints. Why? Because otherwise, how are we going to know if people are illegally selling groceries out of the back of a pickup truck? It's absurd. There is 0% chance that the taxing authority under Article 1 of the U.S. Constitution, which gives the Congress the authority to engage in taxation of interstate commerce and foreign commerce and the like, that when you can stretch that concept of the taxing power all the way out to require consumers of products to register their products with the federal government. That would basically create a police state, a police power that's ubiquitous. That is absurd. That would eliminate the notion of enumerated rights under the taxing power. And again, we're talking about two different taxes. The one big beautiful bill, the $200 transfer tax went away, and they're now saying, but we still need to make sure that you register your suppressor short barrel rifles and short barrel shotguns under the NFA with the federal government to make sure that the people engaged in the business of firearms sales and engaged in the business of firearms manufacturing, to make sure those people have paid the SOT tax to continue to operate in their line of work. It's absurd. They're totally separate things. And yet here you have in this brief on page 10, they're trying to conflate these two things. And again, anyone that can think of these things separately, you know what, my old mentor, Ken Starr, the Whitewater prosecutor, once told me that what makes someone a great lawyer is to take two things that are inextricably linked in the mind and delink them in one's mind. And I think that for those that understand this are more than capable of realizing the absurd argument, in my view, that is being made in this brief here on that point. The last point I want to make is about this Commerce Clause thing. Now, this is crazy. Now, we all understand from the 1934, I think, Szynski case that the whole basis of the National Firearms Act was Congress enacted the NFA as a revenue-raising regime under its taxing authority. Because remember, Congress under Article 1 of the U.S. Constitution has enumerated powers, and it cannot go beyond that. It has taxing authority, and that's how they enacted the NFA. So in this brief as an alternative argument, this argument by DOJ is trying to claim that they can now justify as a backup argument, as an alternative argument, that the National Firearms Act, as applied to these specific things. Remember, the issue in this case is not the NFA in its entirety. The issue in this case is, now that that tax has gone away for the transfer from an FFL to an ordinary citizen, that $200 transfer tax from an FFL to an ordinary citizen, can they still justify under Article 1 of the U.S. Constitution the requirement that that private consumer register that item, that suppressor or what have you, with the federal government and to have their fingerprints taken? And as we've just gone over, it's going to be a stretch for them and the one on the taxing authority. And now there is a backup argument saying, well, we have another power under Article 1 of the U.S. Constitution. It's called the Commerce Clause that allows the regulation of interstate commerce. But here's the thing, folks. During my lecture at the Federalist Society, and we've talked about this on this channel before, and you're like, how does this come back? And here's how it comes back. I point out that when a court analyzes whether or not a statute is constitutional on its face, you have to look at the statute as it is written. If you look at the relevant statute, or the portions of the statute that deals with the old $200 tax and the requirements that you register your NFA item and you get fingerprinted. If you look at that language, there is no element to a crime of possessing an unregistered suppressor, an unregistered short barrel rifle, or an unregistered short barrel shotgun. There is no element in that crime that the government would have to prove beyond a reasonable doubt in a jury trial to convict you of that crime. There is no element in the actual statute that is being enforced that refers in any way, shape, or form to interstate commerce. Period. So here you have the Department of Justice is trying to argue that this statute is authorized by a different enumerated power in Article 1 of the Constitution, the Interstate Commerce Clause, the Commerce Clause, whatever you want to call it. And yet, when you actually look at the elements of the crime that could put you in prison, the government would not have to establish that this firearm or you or anything about this alleged crime touches fingers in any respect with interstate commerce, with commerce or anything at all. And yet the Department of Justice in this brief is trying to say, well, this statute is authorized under the Commerce Clause, but that's BS because the statute doesn't refer to anything involving commerce. And the reason why that's important is I explained to you that the anti-gunners in America have been playing this game, and the way they play the game is to say that, hypothetically speaking, in some theoretical statute that doesn't exist right now, a hypothetical narrower statute could be constitutional covering the same activity or covering these same people. And that might be true hypothetically, but that is not what courts do to assess a facial challenge to an existing actual statute. You actually look at the language of the statute. And here, the NFA statute dealing with that $200 registration tax, the $200 tax which has now gone away, the registration fingerprinting requirement, there's nothing in that statute that refers to commerce. Which means that it is unacceptable for the lawyers, in my view, at the Department of Justice to justify the registration and fingerprinting requirement under the NFA with no tax by arguing the Commerce Clause, because the Commerce Clause is not an element of the actual statute and thus an element of the crime that has to be proven. And here's what the U.S. Supreme Court literally said about this, and there's many examples of this. I talked about several examples during my speech to the Federalist Society and in a couple videos on this. But here's a great example of the U.S. Supreme Court from the late 19th century making this exact point. But this law is still the law of the land. You got to prove that something is actually in commerce if you're going to use the Commerce Clause as a hook. And the NFA, because it was always a taxing authority, never referred to the Commerce Clause in this context in any respect. Here's what the Supreme Court had to say back in the trademark cases case. It has been suggested that if Congress has the power to regulate trademarks used in commerce with foreign nations and among the several states, these federal statutes shall be held valid in that class of cases, if no further. To this is what the Supreme Court said, guys, to this there are two objections. First, the indictments in these cases do not show that the trademarks which are wrongfully used or trademarks used in that kind of commerce. In other words, folks, the indictments have to actually allege commerce for it to connect up with Article 1 authority. And secondly, according to the Supreme Court, while it may be true that when one part of a statute is valid and constitutional and another part is unconstitutional and void, the court may enforce the valid part where they are distinctly separable so that each can stand alone. But it is not, listen carefully, this is important, folks, but it is not within the judicial province to give to the words used by Congress a narrower meaning than they are manifestly intended to bear, in order that crimes may be punished which are not described in language that brings them within the constitutional power of that body. Exactly right. What they're saying is, yes, maybe in some hypothetical future world, Congress could use the Commerce Clause to maybe regulate these NFA items. Maybe. And maybe they could do that. But that's not what happened under the statute. That's not how this statute reads. And therefore, the fact that the Department of Justice is saying, well, we have the power under the Commerce Clause, gets them nowhere in this case. Because you can go to prison for simply possessing an unregistered suppressor. And the government would not have to prove that that suppressor and or you and or your possession somehow touch fingers with interstate commerce, commerce among the states, commerce with foreign nations, whatever. And therefore, it is not a saving way to save the statute by saying that, hypothetically speaking, Congress could have written the statute differently, incorporating the Commerce Clause, and that would be okay. And it doesn't matter because that hypothetical world is not allowed to be written into the law by a court, because in that case, they would be rewriting a congressional statute. That's not their job. Just facially, as I read it, this is a facial challenge, and these laws are facially unconstitutional, and the reference to the Commerce Clause simply doesn't get the government where it thinks it can go. It simply is not good enough. All right, folks, so there you have it. That's my analysis of this case of the Science Shop Foundation versus the ATF and the brief submitted by the Department of Justice. Again, I'm surprised and disappointed in the arguments made by this brief. In addition to the fact, I think, frankly, the Department of Justice should be on the other side on this argument. Maybe they will switch sides on appeal or before the Supreme Court. And I understand that the Department of Justice, technically speaking, is supposed to be the lawyers for the federal government. That is the basic rule of the job. With that said, though, at a minimum, you should at least get the methodology right and draw the proper analogs and go through the jurisprudence correctly. Because what you don't want to do if you're the Department of Justice and pro-Second Amendment is, even if you feel a duty to defend federal law while attacking anti-gun state statutes, you should at least try to get the jurisprudence right, the methodology right, because what you don't want to do is, if you defend federal law, to do it on the wrong legal grounds, and then those wrong legal grounds become the law, and then that has a terrible repercussions in other areas of the law, including the Second Amendment. So yes, I'm disappointed with this brief. I think they should be on the other side of this, and I think they can do a lot better. And certainly it is no excuse to say that talk to Congress, because Congress has already changed the law, and now the logical implication of that, as far as I'm concerned, is that there should no longer be a registration or fingerprinting requirement when it comes to private individuals acquiring from FFLs these so-called NFA items. In fact, to the extent they're protected under the Second Amendment, the NFA cannot even legally apply to them, setting aside the question of congressional powers under Article 1 of the U.S. Constitution dealing with the taxing authority and the Commerce Clause. Again, this has always been viewed as the taxing statute, and the best evidence of that is the Commerce Clause references are not in any of these statutes that would put you in prison if you violate, and therefore you cannot justify as a facial matter these statutes under the Commerce Clause. And of course, there's no more taxing authority here because the tax has gone away. And to somehow think that, my filling out a form and submitting fingerprints information to the federal government somehow ensures that people in the business of selling firearms are going to now go out and get a special occupation tax because of something I do or don't do is frankly stretching things to the point of incredulity. All right, folks, so there you have it. I hope you enjoyed this longer video, but I thought this was warranted because it's such a hot topic on the internet, and I think a lot of people need to hear from me on this topic. So hopefully you at least appreciated what I had to say here. Let me know if you disagree. If I missed some points, feel free to let me know down below. And of course, don't forget to follow me on X at 4Boxes Diner and subscribe both to Rumble and to YouTube. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.